Grant, hello to you. Let's just first of all start with the obvious question. Can he be implicated in a court of law for what Agrizzi has said?
Not by virtue of what he has said directly. So where, for instance, he has said, I was party to bribing X, he cannot be convicted of bribery on the basis of that statement. However, if the police were to go and then trace the money as it left, for instance, his bank account and made its way into X's bank account, and they produced that evidence, we would call that derivative evidence, as opposed to the direct evidence that he's given in the commission. And that derivative, or to give it another name, indirect evidence, can in fact be used. So there, or at least by default. So the basic rule is whatever he has said on the stand in the commission cannot be used. However, what is found by virtue of what he has said can be used by default.
Is that why you think, Doctor, he's been so careful about giving too much evidence away and being too specific?
You would want to say as much as possible. And that's why you would see anyone here saying and giving as descriptive testimony as possible, so that it narrows out what it is that the law enforcement officials could possibly find that isn't linked or isn't covered directly by what the person says.
Let me give you an example, if I may, and I know you have been following this very closely, Doctor, if I may. I want to read this verbatim. This was about the Bosasa CEO, Gavin Watson, and the relationship with former President Jacob Zuma, and I quote from Agrizzi, if I may just add, Chair, he had the type of relationship with the President where he could tell the President what to do. It was frequent. Is that indirect, or is that direct evidence?
So we need to distinguish between evidence which could be incriminating of himself as opposed to evidence which incriminates others. Evidence which incriminates others is admissible against the others in court. The distinction that I've drawn before about direct and indirect evidence relates to evidence which could incriminate him. So on that instance, where he says, for instance, I bribed X, then that cannot be used, that statement cannot be used in a court of law to convict him of bribery. But again, evidence which is derived from that, where the police then go and, for instance, search his bank account and they find indirect or derivative evidence relating again to him, they can use that to have him convicted.
Because many people who have been watching this, and we've seen these comments coming through on social media, I'm not saying social media is the entire country, but the comments we've seen, Doctor, is that if names like former President Jacob Zuma are being dropped, Gavin Watson are being dropped, these bombshells, could we see these people in court as a result of what has been said about them from Agrizzi?
Well, let's just remember that so far what Agrizzi has said is untested. So, yes, it's highly relevant, and to an extent, it seems to corroborate, to an extent, what it is that we were hearing from other sources, and possibly the sorts of things that were exposed by the emails, the millions of emails that were dropped. However, it remains the case that he could be lying. It seems that his evidence is highly detailed, is somewhat believable, but then that's the work that an intelligent liar does. They think through their lies, and he's had, since, by some accounts, since 2016, to think about what it is that he's going to say to implicate other people. Even if he implicates himself, he knows that there are mechanisms in place by which he can seek indemnity, so long as he takes enough people down. And it's an unfortunate part of our system that he who speaks first often gets what we call Section 204 indemnity, which is where you become a state witness, and you are the one who then gets indemnity, whereas you get to take the others down.
And do you think that has been the play for Agrizzi? He knows the evidence he's going to give, whether it's direct or indirect evidence, is going to implicate these people, and there's many of them, ministers, former presidents and CEOs of Bosasa, but he's weighed that up enough against the evidence he's giving that he won't be in the kind of trouble that these other people may be in? Has that been the play? Has it been that calculated?
All I'm trying to say is that we need to realize that it's possible. It's possible that that this might all be a lie, and we will only know this when he is subjected to, at the very least, cross-examination, because when one is allowed to simply tell one story, it's quite easy to get it straight until you are asked how this fact that you've just mentioned ties up with that fact, and you are run through your story back and forward before we can actually believe it.
So, Doctor, help me understand. So when and if this is tested under cross-examination, not if, I think it has to be tested under cross-examination, and he's found to have lied, not suggesting he is, let's say he's found to have lied in this inquiry, then what happens to this self-implication and immunity that you're talking about? What happens to him afterwards if he's found to have lied?
Well, then the problem becomes that this inquiry is about finding the truth. And so he just simply wouldn't have helped in that process, and undoubtedly he's under oath, and so he might be convicted of perjury for that. But in terms of a criminal process, there will be nothing that comes of it, because, of course, if it is all untrue, then it doesn't lead us anywhere. I'm not saying it is a lie. We just have to be cautious to realize that it is his untested version so far.
Doctor, thank you very much for coming in to speak to us this afternoon.